Apologize for the absence of siesta.
Close enough.
That is a fundamental right in Spain, like I imagine you know. But without siesta, we begin the second session, the session of the afternoon of today, with the presentation of Michael Pardo from the Alabama University in the States, and also in his case, I good to thank Michael for to be in Girona, and also apologize for not to be in Mexico last year. That we have a meeting with Larry, and Michael is so kind that he presents a paper discussing with the absence of Jordi. Sorry, and now we have the second round, and we can make this discussion, the other discussion, and so on. Then it's your time, and you have maybe 45 minutes, but is it a little bit short? There is more time for the debate.
Okay, well, thank you very much. I'd also like to thank Jordi and Carmen for organizing such an excellent conference. It's an honor and a pleasure to be invited to share my work here and to be grouped with such a distinguished group of other speakers. I need to commend Jordi on two pieces of wisdom. First of all, scheduling me after lunch and after wine. Very good decision on your part. And second, to not invite any Bayesians to speak here. I'm going to join Susan in piling on and critiquing probabilistic conceptions of proof, although I hope with a constructive purpose. I'm going to raise some different kinds of arguments and try to tie those criticisms into a general theory, or at least my views about what theorizing should look like in this area. So I must confess that I'm presenting this paper today with some trepidation. First of all, I am not a comparativist, and my focus is on legal doctrine, evidentiary issues, and examples as they arise in the United States. Despite my parochial focus, however, I'm going to attempt to draw some general epistemological lessons about legal proof. Second, the second reason for trepidation, in the paper I'm revisiting some issues that I've explored before regarding specific philosophical and theoretical aspects of evidence law and legal proof, and I'm asking quite general methodological and meta-theoretical questions about how to and what it means to theorize in this area and what the point of it might be. And these are difficult questions, to be sure, for any academic area to confront. Finally, I do so against the background of a quite sophisticated academic literature peppered with contentious debates, or at least what passes for heated debate within the United States evidence community. So the paper is exploring at a general level the nature and the purpose of evidence theory. And although a primary focus of this conference is evidence and proof at trial, one theme that I want to emphasize is that the issues at stake here in these debates are not just about what happens at trial or ought to happen at trial. They connect with larger doctrinal and policy issues on both the civil and criminal sides. In the United States, for example, these issues underlie who gets to trial in the first place, which trials will go to a jury, and which verdicts and judgments will be allowed to stand and which will be overturned. In an era of diminishing civil trials, at least in the United States, and concerns with false convictions, these may be as important as any issues facing the law today. And to the extent they turn on what reasonable fact finders could and could not infer from evidence, they depend on evidence theory. More generally, these theoretical issues also affect primary non-litigation behavior, at least to the extent that litigation affects primary behavior. So the consequences here aren't just about trials, they're about the law more generally. And so I said the paper is about the nature and purpose of evidence theory, and this is probably a good place to explain what I mean by evidence theory. I mean a theory, conception, or account of the structure and the nature of the evidentiary proof process and how it relates to the underlying goals of factual accuracy and allocating the risk of factual errors among the parties. I realize that there is much more theoretically and practically going on in evidence law, including a host of moral, political, and economic issues, but my focus will be on the core epistemological issues that I think are necessary, although not sufficient, for a satisfactory theoretical account of evidence and proof. Now, as discussed by Susan earlier, the theoretical debates in evidence law have focused to a large extent on the application of statistics and probability theory to aspects of the proof process. And since I'm writing against this background, I think it helps to keep separate two different projects. The first is the integration as a practical matter of statistical information and formal techniques into various stages of the litigation process and the law more generally. The second is the integration as a theoretical matter of statistical and other evidence into a conception or theoretical account of evidence and proof that accords with the legal system's proof process and its underlying normative goals and purposes. Now, these projects are, of course, related. The theoretical account provides guidance for practical integration as well as a standard by which to assess and perhaps critique current practices. For example, we have no idea whether statistical evidence is or is not sufficient to satisfy the preponderance or beyond a reasonable doubt standards without some prior conception of what is or ought to be required by these standards. Although related, these projects involve distinct methodological issues. The practical issues of integration involve a host of difficult empirical questions that are distinct from the conceptual task of articulating an underlying theoretical account of the nature and structure of proof in light of its normative goals. And my focus in the paper is on this second theoretical project. And in doing so, I identify three constraints that I think a successful theory of evidence and proof must meet. The first is what I refer to as a micro-level constraint. And here a theory has to offer a satisfactory account of relevance and probative value, or the strength of evidence. These are key concepts both for the admissibility of evidence in the United States, and probative value, or the strength of evidence, is also a key concept for explaining the sufficiency of evidence in meeting a particular decision standard. So a satisfactory theory will offer an explanation of which evidence is relevant and irrelevant and why evidence has the probative value that it has. And in addition to being descriptively and explanatorily accurate, a successful theory can also provide a normative standard, by which I just mean a standard by which to evaluate, constrain, and guide particular judgments. The second constraint is a macro-level constraint. So here, we need explanations of the various decision standards. For example, in the United States, for example, the preponderance of the evidence rule, the clear and convincing evidence standard, and the beyond a reasonable doubt standard. And so we need explanations of these decision standards in light of their normative goals regarding accuracy and allocating the risk of error among the parties. A theory should also provide criteria for sufficiency of the evidence and for determining which applications of these standards are reasonable or unreasonable. And these are key issues not only for what happens at trial, but doctrinally they matter in both civil and criminal cases, again, regarding which cases go to trial in the first place, which verdicts will be allowed to stand, and so forth. And as at the micro level here, a successful theory could provide a normative standard for evaluating, guiding, and constraining particular judgments in particular cases. The third and final constraint that I identify is what I refer to as the integration constraint. And here a successful theory needs to have some explanation of how its accounts at both the micro level and the macro level fit together. So a theory is better if its accounts at these levels cohere, and worse if they're inconsistent or leave the relationship mysterious somehow. And I think this is a relatively overlooked area of evidence theory. Any theory regarding standards of proof has to involve or imply a plausible account of evidence at the micro level. As I'll explain shortly, this is something evidence theorists can't simply remain agnostic about, as some probability theorists have contended or assumed. And so today I'll focus on each of these three constraints in turn. But first I want to make a methodological point and explain a few clarifying assumptions. So the methodological point, as I see it, if there is a mismatch between any particular judgments or your intuitions about particular cases and the theory, this can mean one of two things. Either the theory is false or the judgment is wrong. Neither necessarily has priority, but anyone offering a theory needs to provide a good reason why we should override our considered judgments about a particular case. Now, a few clarifications. I think it'll help to clarify briefly what I think is not at stake or contested in these evidence debates, and also to try to clarify a few other potential confusions and mistaken assumptions. First, Statistical evidence is distinct from an account, probabilistic or otherwise, of aspects of the proof process. In other words, whether statistical evidence is relevant, how probative it is, and whether it is sufficient to satisfy a decision rule are distinct issues from whether relevance, probative value, or decision standards are probabilistic or ought to be conceived in probabilistic terms. Second, and similarly, the practical issue of whether statistical evidence and techniques ought to be introduced at trial or not, or any other stage, is a distinct issue from the theoretical issues regarding conceptions of evidence and proof. Third, from an epistemological standpoint, statistical evidence is neither necessarily inferior nor superior as compared with non-statistical evidence. As with non-statistical evidence, it will sometimes be good, relevant, and highly probative, and sometimes not, depending on the context. In other words, there's no abstract qualitative distinction a priori or otherwise, although there may be moral and political reasons for drawing a distinction. Fourth, non-statistical evidence is also based on generalization, so if there is a specific general distinction here, it's at best one of degree and not of kind. Five, probabilistic conceptions may be useful as teaching tools or for capturing and drawing attention to certain aspects of the theoretical process. Finally, number six, with regard to these theoretical issues, I think there is sometimes a false dichotomy presented between probabilistic conceptions and the psychological model of jury behavior referred to as the story model. So the alternative to rejecting probabilistic conceptions is not an evidentiary free-for-all in which whatever persuades works or in which all fact-finding reduces to intuitions about narratives. The story model is a descriptive psychological account of fact-finder behavior, and a particularly good one at that. And any theoretical account would be wise to take account of the best empirical account we have of the behavior of fact-finders. But whether that account is true and whether lawyers present their cases in that way are distinct issues from theoretical accounts of the nature and structure of proof. In short, it's possible to have descriptive and explanatory accounts of legal proof that also provide normative guidance and constraint and that are non-probabilistic in nature. Okay, so turning now to the theoretical project. The dominant theoretical conceptions at both the micro and macro levels is probabilistic. Under this probabilistic conception, contested propositions may be assessed according to their probability, given the evidence, or vice versa, with such assessments conforming to the axioms of probability theory. For example, they fall somewhere on a scale from 1 to 0, with 1 equaling certain truth and 0 equaling certain falsity. The probability of a proposition and its negation equal 1. If you have two independent propositions, their likelihood conforms to the product rule. We can update our judgments to conform with Bayes' theorem, and so on. I argue in the paper that these probabilistic conceptions fail all three constraints that I've identified, and I sketch an alternative based on explanatory criteria, which builds on some of the work that Ron Allen and I have discussed previously, both jointly and in some of our individual work. So under this alternative conception, contested propositions are assessed according to how, if true, they would explain the evidence and the events when compared with competing contrastive explanations. So at the micro level, the dominant conception of relevance and probative value is the so-called likelihood ratio approach. The way this approach works is we're to examine the probability of receiving evidence if a proposition is true, for example, the defendant is guilty, divided by the probability of receiving the evidence if the proposition is false, the defendant is not guilty. So for example, and the classic example is provided by Professor Rick Lempert in his classic article, Modeling Relevance. So here's the example. If we know that the perpetrator of a crime has type A blood, and we have evidence that the defendant has type A blood, the evidence is relevant to proving the defendant is the perpetrator if, one, the probability of this evidence, he is type A, given that he is the perpetrator, is greater than, two, the probability of this evidence given that he is not the perpetrator. So under Lempert's analysis then, and he assumes that 50% of the population have type A blood, the evidence would be relevant. It would be 1 divided by 0.5. The likelihood of receiving this evidence at guilt would be 1, and the likelihood of receiving this evidence if he's not guilty would be 0.5, and so we've increased the odds of guilt now 2 to 1, or 0.67. And the point here is if the first number is greater than the second number, the evidence is relevant for proving the proposition. If the probability of the evidence, assuming the proposition is true, say guilt, is lower than the probability of the evidence, assuming the proposition is false, then the evidence is relevant for disproving the proposition at issue. And the key point here under this theory is that if they're equal, or you have a likelihood ratio of 1, the evidence is not relevant. So here's Lempert's example of irrelevant evidence. Suppose we have evidence that a criminal defendant supports liberal political candidates. If there's no reason that those who support liberal candidates are more likely to commit the crime, the evidence has a likelihood ratio of 1. And under this theory, if you have a likelihood ratio of 1, the evidence ought to be excluded. It's irrelevant evidence. Now, this notion of a likelihood ratio, to be sure, captures something intuitive and important about relevance. It also serves as a useful tool for drawing the attention of students and courts to the issue of how likely evidence would be if the proposition for which it is offered were false, which I contend is an important and often overlooked aspect of relevance and probative value. But as a theory of the meaning of relevance or probative value, or as a normative theory, the likelihood ratio approach does not work. This is so because an increase in posterior probability is neither necessary nor sufficient for evidence to be relevant for proving the truth of a contested proposition at trial. So in pointing to examples in the paper of relevance that do not fit the likelihood ratio theory, I contend, therefore, that the theory does not capture the meaning of relevance, for example, as expressed in Federal Rule of Evidence 401. In philosophical jargon, it's not an analytically true claim about relevance, nor is it a normative standard by which we can measure relevance and probative value. Instead, it will sometimes coincide with relevance and sometimes not. In other words, increase in a proposition's probability may be one way in which evidence is relevant. And the primary example that I discuss in the paper involves an actual trial. It's a relatively simple criminal trial where a prison inmate was charged with committing battery on 2 guards at the prison. And both sides generally agreed about what happened in this case, that the inmate refused to turn over a food tray. And according to the prosecution, the guards went to retrieve the tray and the inmate attacked the guards. According to the defense, he withheld the tray, the guards came in and basically attacked him. Now, the key evidence in this case was a package that had been sent to this inmate by his family, and he had spent months or weeks trying to get this package. He didn't receive it. Several witnesses testify about this, and both sides try to use this evidence to support their case. So according to the prosecution, this inmate didn't receive his package. He was therefore upset. Therefore, he withheld his tray. Therefore, he attacked the guards. According to the defense, because he didn't receive this package, he was upset and he withheld the tray, and therefore the guards retaliated against him by attacking him or to punish him. Now, this was a key piece of evidence and appears to be relevant. If you were the jury on this case, you'd want to know this information. It gives you some sense of why this happened. It seems to form each side's explanation of what happened here, yet it seems also to have a likelihood ratio of 1 because there's no reason to think it makes either theory more likely. Indeed, each side uses it to support their theories of what happened. But if the likelihood theory were true, then all of this evidence should have been excluded as irrelevant. Indeed, often there will be lots of evidence like this at trial, overlapping evidence that both sides try to explain and argue supports their version of what happened. So if you take issue with this particular example, I give several more in the paper that are more stylized examples, and I'll mention one here. I'll skip over the rest for the sake of time. So here's another example. A witness will testify that someone matching the defendant's description was seen fleeing a crime scene. The defendant claims it was his identical twin and introduces evidence establishing the twin's existence. Assuming the judge concludes there is no reasonable basis to distinguish the defendant from his twin, i.e. it has a likelihood ratio of 1, should the witness's testimony be excluded as irrelevant. Now, I would say the evidence is logically relevant in this example, as in the previous case involving the prison guards, despite having a likelihood ratio of 1. And so the likelihood ratio theory is false as an analytic claim about relevance and as a normative theory of relevance. So the upshot here is that evidence can be logically relevant even if it does not distinguish between the parties' cases or theories of what happened. So more generally in the paper, I discuss other limitations on probabilistic accounts at this level. I'll skip over them. The basic point is that even apart from this likelihood ratio approach, an increase or a decrease in posterior probability is neither necessary nor sufficient for relevance. Second, attempts to quantify the probative value of evidence also fall prey to something referred to as the reference class problem, meaning any attempt at quantification will mean the evidence belongs to one particular class, but that piece of evidence will belong to an infinite number of classes, each with their own statistics. So at the very least, any inference regarding the value of evidence will involve a host of auxiliary assumptions about other classes and the distribution in the particular class. So the conclusion in this section then is that probabilistic conceptions do not provide the requisite theoretical explanations or normative guidance at the micro level. The second part of the theoretical project then is at the macro level, and here's where standards of proof become most important. So at this level, regarding standards of proof, we need some account of the various decision rules and when evidence is and is not sufficient to meet those standards. And here, probabilistic conceptions are also common. It's often asserted that the preponderance of the evidence rule means beyond 0.5 likely or greater than 50%. The clear and convincing rule sometimes is articulated as 0.75 or 75%. The beyond a reasonable doubt standard is 0.9 or beyond 90%. And evidence is sufficient to prove a proposition when the probability of the proposition given the evidence exceeds the decision threshold. This is a fairly standard interpretation about which much has been written. As at the micro level, this conception captures some important aspects of the issues, but again, it is also deeply problematic as a theoretical account or normative standard for meeting the underlying goals regarding accuracy and allocating the risk of error. There have been a number of potential problems for probabilistic accounts discussed in the literature, some of which were discussed by Susan previously, and I don't have time to go into all of these problems. Instead, what I'll do is focus on two aspects of the probabilistic conceptions of decision rules, which have not been the much focus compared to some other issues, and that I think make them particularly problematic. And so to illustrate, I'll focus on the preponderance standard as an example, but basically the same analysis with necessary adjustments applies to the other standards. So first, any account of decision standards ought to provide guidance in applying them and some criteria by which to determine which applications are reasonable and unreasonable, but probabilistic conceptions do not fare well here. To apply a probabilistic decision standard, one also must quantify the value of the evidence. And this could be done based on objective data or subjective judgments. We don't have the data for most items of evidence to do this objectively, and even if we did, the complexity, as Ron will talk about next, I assume, may be too great for most trials. And even if we did have this data, then the only reasonable decisions would be the objective answer, which would render fact finders largely superfluous. So we must largely rely on subjective probability assessments. Unfortunately, probabilistic decision standards based on subjective probability assessments provide little guidance on how to proceed. Suppose, for example, you are on a jury trying to decide after hearing a number of witnesses whether the probability of a proposition exceeds 0.5. How do you do this? Close your eyes and think of a number. Suppose you conclude it is 0.6 likely and your fellow juror says it is 0.2 likely. Are they both reasonable? Is 0.99? Is 0.01? How can we tell? More importantly, suppose now you're a judge deciding a motion for summary judgment or judgment as a matter of law. So in the United States, the doctrinal issue on this issue is whether a reasonable jury could find for the non-moving party, which incorporates the decision rule. In other words, whether a reasonable jury could find a proposition proven by a preponderance of the evidence based on the evidence presented. A decision rule of greater than 0.5 based on subjective probability assessment provides no guidance or criteria for determining which applications are reasonable or unreasonable. And a similar problem plagues criminal cases where in the United States we consequently have extremely weak sufficiency of the evidence review under the Jackson versus Virginia standard, which says could a reasonable jury have convicted beyond a reasonable doubt. We don't have any good criteria for saying which applications are reasonable or unreasonable when we have evidence presented. Now the second problem, probabilistic decision standards are non-comparative in a way that may be frustrating the underlying goals of the rules. The probabilistic rules compare the probability of a proposition with its negation, but they should be comparing the competing propositions put forward by each side. This is cryptic, so let me try to explain. Suppose the proposition rule is, as is commonly supposed, trying to minimize errors and allocate the risk of error roughly evenly among plaintiffs and defendants. Now, suppose a plaintiff offers a theory of what happened, and suppose we could quantify the evidence, whether based on objective probabilities, subjective probabilities, maybe even degrees of warrant. Suppose we could do that. Now, suppose a plaintiff offers a theory of what happened, and a reasonable jury concludes it is 0.4 likely. And the defendant offers a theory of the case that they conclude is 0.2 likely. Well, the 0.5 rule, if we conceive of the preponderance rule that way, says the plaintiff loses, even though the plaintiff's offered an account that is twice as likely to be true as the defendant's account. Well, this doesn't make sense if what the legal system is trying to do here is minimize errors, in which case they should go with the more likely of the two stories, or equalize the risk of error. Between plaintiffs and defendants, the plaintiff shouldn't have to bear the risk of error for all the unknown probability space. So the mistake is to assume that any unknown probabilities favor the defendant or the party with the burden of proof. This is inconsistent with treating the parties equally with regard to the risk of error. So the third theoretical constraint that I identify is the integration constraint. And so the integration of conceptions at the micro level and the macro level also creates a bind for probability theories of proof. So notwithstanding the previous difficulties, the conception of standards of proof in terms of subjective probabilities leaves the micro level, relevance and probative value, utterly mysterious. It implies that relevance and probative value are also purely subjective, but then this in turn implies that a particular fact finder could never be mistaken about the relevance and probative value of evidence, and thus the possibility of misevaluation by the jury would never be a basis to exclude evidence, which it plainly currently is in the United States. On the other hand, if the probability theorist concedes there is more to relevance and probative value, the value of evidence at the micro level, that some interpretations are reasonable and some are unreasonable, then it's hard to see how this is not also a concession that the value of evidence as a whole, and thus whether a proof standard is met, also depends on more than subjective beliefs. But if the probability theorist then moves back to more objective probability assessments, for example, relative frequencies, then we're back to the problem that we never have enough data to make these objective probability assessments regarding the evidence as a whole, not to mention the complexity issues, which I'm sure Ron will talk about next. And so we're back to subjective probability judgments, and around we go. Now, the probability theorist may very well have a way out of this bind, but at the very least, he or she needs some plausible explanation, excuse me, of how these issues fit together, and it's not something about which he or she may remain agnostic and still offer a satisfactory theoretical account of evidence and proof. Okay, so what's the alternative here? Any theory is likely to have difficulties, so without a robust alternative, are the probabilistic conceptions the best that we can do? I think we can do better, and I'll close by briefly sketching the alternative account based upon explanatory criteria. So rather than examining the probabilistic relationship between evidence and propositions, either the probability of the evidence given a hypothesis or the probability of a hypothesis given the evidence, we should focus on explanatory relationships, specifically whether particular explanations put forward by the parties or developed by fact finders, if true, would be better or worse at explaining the evidence and the underlying events. Under this conception, juridical proof is largely an abductive process, or similar to inference to the best explanation. It involves a two-stage process: the generation of potential explanations and the selection of one as better or best depending on the decision standard. So for example, the quality of an explanation needed to satisfy the preponderance rule is less than the quality needed to satisfy the beyond a reasonable doubt rule. And there are general criteria that make explanations better or worse: consistency, coverage, completeness, simplicity, absence of gaps, fit with background knowledge, and so on. The key point here is that this isn't necessarily inference to the best explanation, as Susan described earlier. It's not about optimizing the best explanation. It's about the decision standards being cashed out in explanatory terms. The key point is that it's comparative and contrastive between the explanations put forward by each side. At the micro level, relevance and probative value depend on whether evidence is part of or supports a party's explanation or is a challenge to the other side's explanation. This conception, unlike the likelihood ratio theory or probabilistic conceptions, thus accounts for evidence that is relevant but does not distinguish between the cases. Evidence is relevant if it's part of one side or supports one side's explanation, or put forward by the other side as a challenge to that explanation, regardless of whether it is also part of the other side's explanation. And its probative value depends on the role it plays in each side's explanation or in distinguishing between them. So this account explains why evidence is relevant or not in the various examples that I gave. The evidence regarding the tray and the package was relevant because it was part and supports each side's explanation as what happened. In the blood type example, the fact that the defendant is guilty explains why blood matching his blood type was found at the scene, and so forth. It also explains why evidence is not relevant in the various examples given there. At the macro level, then, we can articulate the various standards of proof or the various decision rules based on explanatory criteria. For example, under the preponderance rule, fact finders should infer the best explanation, and the party with the burden of proof ought to win if that explanation includes the formal elements, and the party with the burden ought to lose if the best explanation does not include one or more of the elements. This rule may better instantiate the goals of minimizing errors and equalizing the risk of error among the parties to the extent that better explanations are more likely to be true than worse explanations. And each side now bears an equal risk of error. And it's comparative, so no side is benefiting from unknown possibilities. Under the beyond a reasonable doubt rule, then, we can explain the decision rule as whether there's a plausible explanation that includes the formal elements and no plausible explanation consistent with innocence or that fails to include one or more of the elements. Unlike the probabilistic conceptions, explanatory criteria also provide some guidance and criteria beyond both the empirical story model and probabilistic conception for both fact finders applying the rules at trial and for courts reviewing those decisions. Although admittedly less precise, there are objective ways to examine and discuss explanatory relationships between evidence and competing propositions, even if there will be disagreement in some cases about which explanations are better or worse and what makes an explanation better or worse. Other things being equal, a consistent explanation is better than a contradictory one. An explanation that accounts for more evidence and more important items of evidence will be better than one that can't account or explain them. An explanation that adheres with background knowledge and does not require extraordinary assumptions will be better than one that is inconsistent with background knowledge or requires unrealistic assumptions, and so on. So these explanatory criteria connect with the deeper doctrinal issues on the civil and criminal side. They provide some criteria for assessing which applications are reasonable and unreasonable, and may also provide a burden of explanation and vocabulary for reviewing courts and applying the various doctrine that matters in the United States for determining whether we're going to allow a trial in the first place or whether we're going to overturn a verdict. This explanation, or this explanatory conception, is also perfectly consistent with the practical integration of statistical evidence and techniques into the litigation process. Under this conception, the key question, as it always is what best or better explains this data. The explanatory conception also satisfies the integration constraint. Accounts at both levels cohere and rely on the very same explanatory criteria, and this avoids the problems regarding probabilistic conceptions of proof. So the explanatory account is able to satisfy each of these three theoretical constraints in ways that the probabilistic conceptions cannot. I think I'll stop there.
Okay. Thank you so much. The debate is open. Susan. Yeah.
Okay. Thank you. I have one very simple factual question that I hope you can clear up for me, and then something a bit more complicated. You refer to the story model as well confirmed empirically. And I looked at the footnote with great interest and found one study referred to. Did you pick the best of a lot, or is it just the only one?
There's quite a few.
Okay.
I'll provide you with more sites for it.
Yes, yes, okay. It's just that
there's a book by Vidmar and Hans called The American Jury. That's a summary of the underlying studies, but I'll send you the sites.
Yeah, okay. I just said I would never take one study in this area as confirming anything.
It's
yes,
many
okay.
more. Okay.
That was just me being suspicious.
That's me being bad and footnoting.
Okay. Tiny scholarly point, so far as I know, Peirce, who's responsible for introducing the word abduction, never presents this in terms of inference to the best explanation, which is a more modern idea. Mm-hmm. Okay. Now to the more substantive stuff. Of course, we're entirely in agreement negatively. Right? This Bayesian stuff won't wash. You, I think, show in admirable detail why it gets you the wrong answer in these particular instances. I tried to show that conceptually at the bottom, it's unintelligible. We don't know what the hell they're talking about. But there are two differences between us I'd like to explore. I'm not sure whether one of them is very serious or not, but I think the other one might be. One is that by my lights, supportiveness is only one dimension of what we should be looking at, which I think is relevant, for example, if you're trying to integrate an epidemiological study into a causation argument in a tort case, where you may have a very high statistical probability, but the epistemic probability or the epistemic likelihood of that thing being true is very low, right? So that would be a failure of independent security. And I'm sort of curious why you discuss this entirely in terms of the one dimension and don't take account of the others that seem important to me. And then the other thing I'm simply not clear about, and I suspect that you moved a little in the course of the talk, I'm not sure. I got the impression from reading the paper that you were tying what I would call supportiveness to the best explanation. And then when you talked that it was a matter of the better of two, the two offered by the rival parties, I have much less difficulty with the latter concept than with the former, but because the former seems to play quite a large role in the written text, I feel a little confused about which you intend. Okay, so the first question is about, do you really think it's as one-dimensional as you suggest? And the second is, can we get clearer about whether we do or don't agree about the role of explanatoriness in this?
Well, can you clarify the second part again? I'm not sure I understood the distinction you were drawing.
Okay. My account is articulated in terms of a concept I call explanatory integration, which I described as differing from inference to the best explanation, insofar as I understand that. First of all, in not being optimizing. It's a matter of grade, right? And secondly, in not being one-dimensional, because it's always something explains something. And I'm interested in the explanatory relations going in both directions, okay? And if you're not really optimizing, the difference between us there is much smaller than I thought it was.
Yeah, I think that's right.
And that's what I'm trying to clarify.
Yeah, okay? I tried to clarify that as well. Yeah, I don't see it in terms of optimization either. I see it as about competing contrastive explanations between the parties, and I also think the explanatory relationship can go in the other direction as well. So I don't think we're disagreeing that much.
Okay, so there's no serious disagreement.
Yeah, right, I think that's right. I think you're identifying certain variables and contrasting them as different variables. I'm seeing them as all part of this explanatory criteria that make one side's story better than whether it's support, integration.
Oh, but I think that's a separate issue.
How so?
Okay. I don't want to hog this. We can do this privately if need be.
Okay.
But, okay, just one more try. As I see it, supportiveness is one dimension of evidential quality, but not sufficient for even in something like an ordering, better or worse, right? I think we've established that we disagree less than it might superficially appear about the understanding of supportiveness. But I don't see anything in what you said about the other two dimensions that I call independent security and comprehensiveness.
Well, I think independent security and comprehensiveness, again, I want to build into an account of whether an explanation is better or worse. So I think that's where we're disagreeing. Okay. It might be terminological. I think if we took cases, we would agree on better or worse. So I think we're just maybe having a terminological difference there. Where I think maybe
if you just build it in, we're not going to disagree on substance. That's going to be words.
Right, that's what I'm saying. Yeah, that's what I'm emphasizing, yeah.
But basically what you're telling me is I'm to understand it as built in, though you didn't specify it.
I thought I did. I thought one thing that makes an explanation better is how comprehensive is it at explaining the evidence. I do think those criteria are there, so it's really, we're just arguing about words. Where I do think maybe we differ is I think the quality of an explanation depends on the standard of proof. So I'm offering this as a standard of proof. So the better explanation under the preponderance rule is going to be, the criteria needed for a better explanation to satisfy the preponderance will be less than the beyond a reasonable doubt rule. I'm not sure you're willing to go there. That's where I was trying to push you with your question about degrees of warrant.
Yeah, I think I'm not willing to go there, but this is a matter for a private discussion about why you are and why I'm reluctant, and maybe we can find middle ground. I don't know.
Right. Yeah, I think the only difference is I'm trying to explain the standard. You're trying to explain the concept.
That's right.
Right. Okay.
Yeah. And I might build into what you do legally, now you've got my theory in hand, the same way you try to build the other things into explanatoriness. Yeah.
That may very well be true.
Mike, interesting paper. I remain puzzled, as I have been, about your and Ron's work on inference to the best explanation for some time about one particular point.
Use the microphone there.
Yeah. Can you
Sure.
use the microphone?
We have had a running battle, the three of us, about inference to the best explanation for a long time. And I'll try to raise a question without repeating questions I've put to you before. Essentially, it's this. You and I agree, I think Ron does too, that one of the functions, perhaps the principal function of a standard of proof, is to try and bring the distribution of errors into line with what we regard as an acceptable ratio. Okay? Mm-hmm. Now, maybe that's 10 to 1, as Blackstone thought. Maybe it's 2 to 1. Who knows what it is. But your criterion basically boils down to the following. Provided that the prosecution has a very plausible story of guilt, mm-hmm. and that the defendant can proffer no plausible story of innocence, mm-hmm. then and only then, as I understand your analysis, would the jury or a judge, if it's a bench trial, be entitled to convict. Mm-hmm. Okay. Puzzle. Suppose that standard were implemented. Have we any reason whatsoever to believe that the frequency of error, the two kinds of errors associated with the implementation of that standard, would produce anything close to what any of us regard as an acceptable error frequency pattern? Mm-hmm. And if not, if, as I suspect, not, that's just a kind of a stab in the dark, that, well, you know, it sounds good. If the defendant doesn't have a plausible story and the prosecution does, that's a good reason to convict. Mm-hmm. If, as I suspect, we haven't a clue what the error profile would be of mm-hmm. trials conducted under that regime, mm-hmm. What would your response be if, after putting this in place, mm-hmm. and letting a few years go by and having people in innocence projects dramatically grinding out studies of errors produced by the system. Mm-hmm. Suppose we discovered that it was at Voltaire's level, 2 to 1, mm-hmm. and not 10 to 1. Mm-hmm. Is there any way you can imagine, consistent with the story approach, tightening up the standard of proof tighter than one side has a very plausible story and the other side doesn't have a plausible story at all?
There are a couple of issues there. So first of all, I don't think that sort of precision is possible. I don't think we can construct some decision standard that will give us these kind of ratios in a precise way. I think we have to do it in terms of implementation in a more crude way. So I think...
I'm willing to be very crude.
Okay, so here's what I think happens. If we don't have something like the beyond a reasonable doubt rule, what's the fact finder likely to do? They're likely to say, well, I'm going to decide what's more plausible, competing between the two, something very much like the story model, which also looks a lot like the preponderance of the evidence standard, figuring out which side's story is more believable. Now that, we think, will not create this ratio of skewing errors in favor of defendants, right? So now is a situation where we want to intervene by creating a decision rule that's likely to push decisions the other way. And I think the decision rule of plausible story of guilt, no plausible story of innocence does that, or is likely to do that, to the extent we think that rule is likely to...
It's bound to push it up.
Yeah, it's going to push it in the right direction. And also I think that's a pretty good description now of the way the rule works. I think that there's two ways defendants will win at trial. Either they'll show the prosecution's story doesn't make sense, or they'll offer a decent story of innocence. In the absence of that, they'll likely be convicted. So I think the world we live in now is a lot like the one you've identified. Maybe we could be more explicit in how we explain this to the jury, but even despite the badly worded beyond a reasonable doubt instructions, I think jurors often operate that way anyway. Now, if we did find out after the fact that we're getting too many false convictions. One way to approach that would be to try to construct another decision rule that does it, but there are all sorts of other ways we might do that as well. We should try to figure out why we're getting these false convictions, and it might be because the evidence we're introducing is a problem, or it might be the cases we're taking to trial are a problem, and so we can fix it in maybe an infinite number of other ways as well. I'm not sure the answer to the question of what would be the best way to do that, but I think we'd have to have a lot more information, not just about how many false convictions we're getting, but why. Now, if we do want to construct decision rules based on explanatory criteria, maybe we could make it tougher and say it has to be not only plausible, but really plausible, or really, really plausible, or you can't think of any possible way in which the defendant could be, or something like that. Maybe that would work, maybe not. I'm not sure the answer to that question. I think just as a general matter, what the standard is doing, as we explain it in this explanatory approach, is push decision-making in that way, away from what fact finders would do in the absence of this decision rule, which looks a lot like the preponderance rule.
I have no quarrel at all with the idea that the barred version of this, namely no plausible story of innocence and a very plausible story of guilt, will raise the standard over the preponderance. It's not at all clear to me that it will make it anything like as demanding as we used to think barred should be.
Mm-hmm.
Whether barred actually has ever been as demanding as theorists of evidence think it is an open question. But I was just puzzled to see whether, should we discover after the fact, which is the only way to discover it, that this rule of evidence, if implemented, would fail to satisfy our expectations with respect to the frequency of kinds of error, if you had in mind either modifications of the explanationist paradigm, or, as you've now just told me, if you might not look for changes in other rules of evidence with a view to making conviction of innocence more difficult. Thank you.
Sure.
Michael? No.
Paul?
Yeah, Paul.
Thank you. This issue of Blackstone and numbers, right, which is also in your paper, Mike, and obviously it's come out in the discussion with Larry as well. Larry, you keep mentioning the fact that in the history of discussions around these issues, different numbers have been quoted. And the inference you seem to draw from that is that nobody can decide what the number should be.
No one has decided what the number should be.
A different inference might be it's not about numbers. The numbers are irrelevant. Let me just...
The numbers can't be irrelevant.
Well,
because if they're irrelevant, how do you fix what the standard is at all? If you,
you can't do that.
If you have no preferred view about what the value of the ratio there is...
The answer is you can't answer that question. That would be the answer. But if the numbers are irrelevant, that's what I'm positing. And, I mean, exegetically, no one surely thinks that Blackstone was actually thinking in these terms when he wrote that passage, right? He wasn't literally meaning that it'd be better if the criminal courts were routinely acquitting 10 people, or 9 for one, or whatever the number is meant to be. The way that we've cashed out that notion in our book is to say that what it means is that the distribution should be asymmetric, and not just a little bit asymmetric, but steeply asymmetric. That there should be a recognition that a wrongful conviction is a more serious moral harm than somebody's being acquitted when they're factually guilty. If that's what it means, that it's to be understood as a rhetorical or symbolic commitment to something that's best cashed out as something like a steeply asymmetric standard of proof, then it seems to me that the only way to develop that thought is through thick description of particular institutionalized practices. In other words, that what that actually entails in practice, a steeply asymmetric standard, is rooted in actual institutions that have tried to apply and develop that idea over a significant period of time. Now here's the question. If something like that picture is right, it would mean not that normative philosophy becomes sociology, it would simply mean that sociological and cultural data are relevant for normative theorising, and I think that to be correct. If something like that is right, then I just wonder where that leaves the choice that you make right at the beginning, not only of this paper, but your general work in this area, which I've enjoyed and benefited from over the years. I wonder where that leaves your decision to make the project epistemic, and to say, oh, the other stuff is moral and political philosophy, let's not talk about that. Because it seems to me that if you want to cash out a thick practice of criminal adjudication, or any kind of adjudication, then I'm not against generalisations, and I'm not against making comparative distinctions between civil and crime. It all works at some level. The epistemic dimension is part of the account. But I think, I'll put to you, that it's going to radically fall short, not only as a theory of, I would say, criminal adjudication, because I think a theory of civil adjudication has to be something different. It's going to radically fall short as a theory of that in general, but also more specifically with regard to these quite particularistic questions that we're addressing now, such as, what does Blackstone mean when he says what he says?
I'm not quite sure how to respond to that, but let me try. I don't care what Blackstone meant. But I see a third possibility. I think there's a false distinction here to say we have to care about the distribution of errors on one hand, or some sociological description about why we have these concepts, or symbolic meaning behind them. And that's to think about the risk of error ex ante, not ex post. So rather than thinking about, does this rule produce the ratio of errors we want, we can think about it from the beginning of the trial of how do we want to allocate the risk of error at the start. So in a civil case, we want to say there's a level playing field. Both sides have to offer the best explanation. They can use any evidence they want to try to skew that in their favor, which is what they should be doing, but we're going to treat them equally. They're going to, just to use a metaphor here, they're going to have the same size goal. They're going to play by the same rules. Now, in criminal cases where we're concerned about allocating the risk of error away from defendants, we create all sorts of rules that are asymmetric for that reason, but they're not necessarily about producing a ratio at the end of the day. They're about setting the rules of the game ahead of time in favor of one side or the other, and then parties introduce evidence to try to overcome that burden in some way. So that for me, I think, is a better way to think about allocating the risk of error. In the absence of this information that we don't have to do this kind of precision, one thing we can ask ourselves, and this is a moral point, I think, and a political point, in addition to an epistemological point, is how do we want to set the rules at the start? Do we want to treat the parties equally or not, and why? For all sorts of historical and political and sociological reasons. But once we have that, so a lot of what I'm doing is conditional in that sense. Given that the rules are set out to do this, here's a way to think about it that seems to conform with that. And I don't have to satisfy the end of the day distributional requirements to say we still can have an epistemic goal or an epistemically focused rule that seems to do this.
Andres.
No, David's question is more.
No,
is it connected to the? Oh, you got it.
You repeat the story, I believe, the myth that
With the microphone, you see
frequently
if possible.
occurs in the literature to the effect that if error minimization, not error distribution, but error minimization, were our principal aim, that a standard like the preponderance of the evidence would be the obvious standard to go for. Alex Stein made a botch of that argument 3 or 4 years ago, and I'm wondering why you're repeating it. Surely you learned at Ron Allen's speech the fact that the distribution of error, the frequency of error that occurs is going to depend in large measure on the distribution of guilt and innocence as between the parties in the case. So that if, for example, we're having a criminal trial and we know in advance, or it just happens to be true in advance, that 98% of the people that the district attorney brings to trial are guilty, okay, then in terms of error minimization, what we want to do surely is to elect a standard of proof that's about 2%, right? Because that will capture virtually everybody who's guilty. On the other hand, if most people who go to trial are innocent, clearly the best way to reduce error is by having a standard of proof that's extraordinarily demanding, because then we'll convict almost none of the people, the innocent ones, who are coming to trial. So I'm puzzled as to why this, I think, confusion is still being promulgated to the effect that if we're really committed to minimizing error, indifferently to whether it's error of one kind or another, then obviously the appropriate standard is the preponderance of the evidence.
Can I say something before you answer that question?
Sure.
Larry, you're absolutely right.
Oh,
Which shows what you said about the criminal process is absolutely wrong. You accused me of having the view that we want a high burden of persuasion to affect the ratio of errors. What I have been telling you for 10 years now, and Michael the same, is exactly that there is no relationship, no algorithmic relationship between the burden of persuasion and outcomes. Zero. That's the point you're now making to Michael, that there's no algorithmic relationship between the burden of persuasion and outcomes. You're right. But why don't you think that applies in criminal cases, as we've talked about over and over and over again?
I didn't deny that it applies in criminal cases.
Yes, you did. You said we agree. You said we agree that you impose a high standard of persuasion in order to effective an error ratio. I don't agree to that. I think that's all nonsense, which I'm going to be talking about here in an hour and a half or so. Because you have no idea what's going to occur. Zero. Until you do tough empirical work and figure out exactly what those baselines are and what the assessments of probabilities are, or however juries or judges decide cases. You're absolutely right about that. But that's why it's crazy to talk about high burdens of persuasion in criminal cases affecting an error ratio. It doesn't. It might, but it would be by happenstance.
I think what you're doing, Ron, is confusing two questions. One is...
And I didn't even have wine at lunch.
One question is, what can we do to minimize errors overall? The other is, what can we do to distribute errors in certain kinds of ways? Okay, never mind error minimization. Now, the point I was trying to make to Mike was, if our concern is with error minimization, independent of error distribution, which I took him to be saying, then he suggested, as Alex Stein does, that the right standard of proof was the preponderance of the evidence, because that would, so Stein argues, and I think Mike argues, that would produce the smallest number of errors, regardless of whether they're errors of one kind or another, than any other standard of proof would.
Which is false.
Which is false.
But it's also false about error distribution.
No, it's not. They're doing completely different things.
Well, I'm going to show you that it is.
Okay, I'll wait for that.
Okay, so I'll just respond briefly to that. My point there is a conditional one. In the absence of that information, I think you'd want a standard like the preponderance standard that says of two explanations, the better one is more likely to be true. If you knew something about the distribution, then maybe the point you're making holds. So maybe I should have been more clear about it.
Suppose we know that most plaintiffs in civil cases don't have a leg to stand on.
Well, then it's more complicated too, because then the lower decision standard or higher one will then affect the cases that are brought to trial. And so this is too, but that's why I don't want to think about this in terms of producing an outcome ratio. I want to think about it in terms of how are we going to set the rules of the game at the start, whether we're going to treat the parties equally or not with regard to this risk in the absence of this information or not, whether we're going to skew things against or toward the defendant in criminal case at the start. What sort of risk of error each party is going to bear relative to each other. I think we can make arguments about that, both epistemological arguments and moral and political arguments. We don't have to talk about, I mean, we could, but we don't have to talk about producing an optimal ratio. I think that we can't do that. And we also then don't have to fall back in purely symbolic rhetoric about why things are important. The rule itself will matter, but it will matter in terms of allocating that risk at the start and what we think the relative ratio should be, or the relative risk should be in that situation. I think there's a way to talk about that without having to prove it produces an optimal number of errors one side or the other, or without falling back on just moral rhetoric.
Thank you.
I have a comment and a clarification question. On page 25, you have this example with a victim who dies of poisoning, and that's intended to show that an increase in posterior probability is not necessary for evidence. Now, this example has the same structure as many other examples in the literature in probabilistic causation. There's a very famous example where a golfer hits the ball and the ball is badly sliced, which lowers the probability that the ball will go into the hole, and then the ball hits a tree and then falls into the hole for a miraculous hole-in-one. Now, the way in which people who defend probabilistic causation solve the problem is by going to the micro level and trying to see how, if you conditionalize on more minute events, then you're always going to get an increase in probability. So maybe with the poison example, you might be able to do the same, and then it would not be a counterexample. Now, even if you don't think of this as at the micro level, I don't know if there's a response to this example by Sherry Rausch in a paper in Philosophy of Science from 2005, in which, from the point of view of the Bayesian, she's also able to conditionalize in such a way that you would never get a decrease in probability. So I think it's not like a killer counterexample to the idea that an increase in probability is a necessary condition for evidence.
Thank you.
That's the comment. And my question is about the way in which inference to the best explanation works at the micro level. You say that, this is on page 35, that evidence is relevant if it is part of one side's explanation. But I thought that the idea of inference to the best explanation was that to explain the evidence itself. So how's the evidence also present in the explanation when we're trying to explain is the evidence itself? I didn't get that.
Yeah, I think so I conceive of it as explaining not only the evidence, but the underlying events that gave rise to litigation in some way. So a party offers an explanation as to what happened or why this happened, say in the example involving the prison inmate attacked by the guards, one side saying, well, here's our explanation of what happened in the case, and now we're introducing evidence that makes that a better explanation, not only of that evidence that they're hearing, but also what happened. So it's an explanation of what happened, and the evidence is relevant if it helps to support that explanation of what happened.
Okay.
Does that make sense? Yeah.
Michele Tarufo.
I'm here. Now, I'd like to have your more detailed opinion on a point that you touch in your paper at page 9 and 10, while talking of burdens, burden of production and burden of persuasion. And you then say the burden of production is a function of the burden of persuasion, because in the sense that parties will have satisfied the burden of production when they have presented evidence from which a reasonable, well, couple of remarks on that. I know that the expression burden of persuasion is very widely used, but I get the impression that it is rather misleading, in the sense that shifts the attention of the reader in the sense of the psychological status of mind that the evidence should create in the judge or in the juror. And I have the impression that the equally common expression, burden of proof, may be more clear or at least not misleading, but this is just a matter of language. My remark is this. First, you correctly said at the beginning you are not a comparativist.
Have I demonstrated that?
No, that's correct. But I have to add that in several legal systems there is no burden of production. The German doctrine says yes, the Italian doctrine says no. Anyway, I think that there is no real burden of production in many civil law systems. If it is so, as I think it is so, this dialectical connection, let's say, between burden of production and burden of proof fails. And you are left only with the final burden of proof. One remark more, where there is a real burden of production, like in the American system, the fact is that there are no general standards for this burden, and on the opposite, the judge has a broad discretionary power to modify or to say, you should come with this item of evidence, for instance, because this item of the evidence is in your possession, independently of whether you are the plaintiff or the defendant. Well, if it is so, and I believe it is so, it is not clear to me this link. The party satisfies the burden of production when they come with evidence enough to satisfy the burden of proof. Because the standards of the two burdens may be different. The burden of proof is not modified by the judge. The burden of production very often is, also in some civil law systems. For instance, the Argentinian talk of the carga dinámica de la prueba, just in order that there is something similar in the civil proceeding in Spain, la proximidad probatoria, but all this is not directly connected with the standard by which the final decision is made on the basis of the burden of proof. So the point is rather complicated, I somehow, because in many cases there is no burden of production. When there is, it is a very flexible standard upon which the judge has broad power. And in any case, when there is, the standards for the two burdens may be and often are different. Final remark, it's clear that the intervention of the judge, where the judge can intervene on this point, has effects also on the distribution of errors, because it determines in a way, directly or indirectly, the final outcome of the decision, just manipulating, so to say, the distribution of the burdens between the parties. And if it is so, this is a factor on the problem of errors, the minimizing or correctly distributing, that cannot be set aside, because in the practice of the administration of justice, this is very often a way how judges predetermine the final outcome of the case.
Just two brief responses to that. So first of all, in the United States, the two are linked doctrinally at least certain points in the process. So for example, in a summary judgment motion, the judge is deciding explicitly in terms of the burden of production is linked to the burden of persuasion, whether a reasonable jury, based on this evidence put forward by the non-moving party, is sufficient under the decision standard. I'm curious, not being a comparativist, about the systems where you say there's no burden of production. It seems there is one functionally, just by virtue of the fact that someone has a burden of persuasion, so their burden of production is to produce enough evidence to persuade someone that the burden of persuasion has been satisfied. That strikes me as at least a functional burden of production, even if we don't call it that. But again, I'm no comparativist, so I want to hear...
You know, in such systems, the rule is that there is proof or not. I mean, a burden of proof is satisfied or not, independently on who produced the evidence.
I see.
So if I come with a document that I had no burden of producing,
right?
But it is accepted.
But just as a functional matter, if there's a burden of proof and you have it and you don't produce any evidence, you lose. Right. Unless the other side produces the evidence for you.
There is no,
right.
so to say, subjective connections between the two burdens.
Thank you.
Now we can open the debate to all of you. Some question? Maribel, with microphone, please.
Thank you.
Encendido.
No, it's I think it's just a philosophical question. It's about your first sentence. When you start talking, you said, this is my theory, conception, or account. Mm-hmm. So, the possibility to use theory, conception, or account as synonymous, you know, and then the same very question you put before about normative, descriptive, and evaluative, probably. Just to know is not, I mean, it's seriously a philosophical question about the idea of providing a theory as what, and or providing an account as what, or a conception as what. You have been using the three words, most of the time conception, when you feel comfortable with the idea that this is my approach, and some of the time when you want to be serious, my theory. So the first question is just a clarification about if you really believe that the use of these three words in your paper and in your explanation are synonymous or not. Or then, if you say yes, what do you mean? What do you mean by this account theory or conception? The second one is also, excuse me all of you, but it's small philosophical questions to understand, not probably very, you know, focus on the topic, is about the question, what is a good thing to investigate or to search for if we want to know that? This question is a common sense question. If I need to give an answer to something and I say, well, what would be a good thing to know, a good thing to investigate to arrive to a conclusion about a topic? Then if we are a lot of people around, we can ask, we can be pluralistic, and what do you think would be a good thing to investigate? And what do you think? What do you think? Wow, I never thought that that would be a good thing, and we put it. So if this is what I guess sort of a common sense activity, don't you feel, and please, I apologize for this, don't you feel that sometimes the way of presenting these activities with the standards, rules, procedures, etc., is something quite similar to what the statisticians do when they talk about epistemic correlations, that in fact they are just talking about intuitions? And to be honest, to say that we try to give names to common sense intuitions, well, is needed too? That's the second question. And the third is, I would like to explain you a tale. I've been thinking when I listen to you. The tale is, imagine a guy that has been wrongly accused several times in a village, and then he decides to move to that village and goes to another one. Was looking for a new village, and he said, where I'm going to be living? And there is a village in that place that they have just one rule. We do as much as we can to minimize errors in our convictions. So he arrives there and he says, well, I'm very happy to be here because, you know, I've been accused false. And then there is a jury or a group of people in charge of taking this sort of decisions. And one day something happened and he is accused. That guy that arrives there is accused. And then the jury starts to use the only rule they have. And as you said this morning, the first one said, well, you know, the new guy that arrives probably has been him, is formally accused, and they start to accuse, not accuse, to prove, not to prove. At the end of the story, the one that is probably we perceive wrongly, probably, maybe, if we, at the end of the day, he is not convicted. The day after, that judge is dead. The one that is more the guarantees are stronger is dead. And that happened every day, every day. At the end of the day in the village, there is that guy and another one. And the other one says, because we follow the only rule to minimize these sort of mistakes, we are here. And we did it well or wrong. I'm asking you. Think tomorrow about the answer. Don't think now. Mm-hmm. Because if you say...
Okay, thank you.
No, I mean, because if you say we did wrong, we did right, and if we say we did right, we did wrong. Just think about it.
Uh-huh. Okay. I'm curious to get your thoughts. Maybe we can talk more about this, of what the distinctions would be between calling it a theory, a conception, or an account. I just mean some collection of propositions that provide understanding to this. What I want to emphasize by conception is that we have a target concept, this whatever practice we're talking about or the standard we're talking about, and there's different ways to theorize that, meaning provide some propositions that provide understanding of this underlying thing in some way.
Good understanding is what then?
I'm sorry?
Understanding then is what? I would like just then
so,
what understanding is.
So understanding how the rule relates to its underlying goal. So if we have a rule like the preponderance rule, and we say, well, why do we have this rule? And this is a policy choice. Say it's to treat the parties equally with regard to the risk of error. It provides understanding of how the rule might be doing that, or is supposed to do that. And so here's why I say, well, you could have a conception of that rule, probabilistic, for example, that doesn't seem, it's utterly mysterious how it could be doing that. If it's doing what we think it's doing, it doesn't seem to fit at all. Here's a different conception of this rule. If we understand the rule this way, then it might be doing this. Now, there's a basic underlying question here. Why do we need a theory at all in this area? Why do we need a theory of anything? Maybe we should just have these practices. But the problem here is that in applying these legal concepts, just by doing that, you're implicitly invoking some conception of what the rule requires or what the concept requires in some way. And so one thing I think it's helpful for a theory to do is try to make explicit what's implicit in those judgments, and that's the kind of understanding that might be provided. Now, maybe that's good or maybe it's bad. It's an empirical question, but I think there's value in trying to articulate what's underlying those judgments and then to examine whether this is principled or not, whether it seems to fit or not with our rules. We might say we have a conception of the rule that's meant to minimize errors, and when we start to articulate it in terms of point 5, we realize it may not be doing that. It may provide understanding by which we can then revise those practices.
Making it explicit would be an answer?
I'll take it, sure.
Daniela, with microphone, please.
I have a question. Oh, sorry, I didn't. I have a question about.
Doesn't work.
Okay. I have a question about the consistency of the best explanation model and the story model, because you refer to it when you are analyzing in the paper the preponderance of evidence standard, but I want to know what's the relationship between them in more general terms and specifically what I think most important, if this model is also an holistic model of if it leaves space for atomistic analysis of the sufficiency of evidence of each element of civil liability or criminal liability.
Thank you. So a couple of points in response. First of all, the relationship between inference to the best explanation as an account of the proof standards and the story model. I think that they will, so I think they're distinct. They will often, the outcomes will often overlap between the two, but you could have divergence between the two in a couple of instances. So on the one hand, the better explanation of what happened could be quite general, whereas the story model posits fact finders will develop quite detailed stories about what happened that explain what happened. So you could have a situation, for example, in tort law in the United States under the doctrine of res ipsa loquitur, where a plaintiff might win and ought to win under the preponderance standard just by offering an explanation like the defendant's negligence, no matter what it was, is the best, it's a better explanation for my injuries than a non-negligent explanation, even though there's no detailed story that supports that. So that's one instance in which the outcomes implied by inference to the best or better explanation would diverge from the story model. Often they will overlap. Another situation where they might diverge, sometimes the better explanation could be disjunctive, meaning it could be either A or B happened. If either of them happened, they support one side versus the other. So, and those could be inconsistent with each other, but they may support one side. So rather than developing a detailed story that wins, just having these two inconsistent possibilities, both supporting one side, could be a better explanation than the third possibility that supports the other side. So I think there will be situations, even under the preponderance standard, where the better explanation might diverge from what fact finders do under the story model. And I think that that's another situation where you can use this theory, this account, or this conception to provide a standard, so to make judgments or evaluate underlying judgments by fact finders who might be operating consistent with the story model. The second question I think you raised was about holism versus atomism and whether this leaves room for judgments about individual items of evidence. I think yes, I think that, so on the one hand, the probative value or the relevance of evidence will be contingent upon the explanations offered by the parties, but once you have that, you can still make judgments about particular items of evidence, whether their prejudicial effect is likely to outweigh their probative value, contingent on whatever the explanation is. You can still make any of the judgments you would make about individual items of evidence, but you'd have to recognize that the value of the evidence depends upon the explanations put forward by the other side and the other evidence that you have. So there's nothing necessarily that follows from accepting this approach that says you can't make evaluative judgments about individual items of evidence. Does that answer that?
Well, any other questions? Paul?
Just a very quick suggestion that's just occurred to me. I wonder whether it would be clearer for you to talk about inference to the best juridical explanation. Partly so you don't get mixed up with other versions, but also to underline your point, which I've only just really got, actually, listening to what went on, and I've read the paper before, that it's not just the standard of proof in the particular context of litigation that matters, it's the particular legal decision that has to be taken that is determinative of the bestness of the explanation. The quality or sufficiency of the explanation is predicated on the particular legal determination that has to be taken at a particular time, whether it be admissibility determinations or issues on summary judgment or whatever it is. So I know this will now mean changing your language, but I just put it to you. But if you call it inference to the best juridical explanation or something along those lines, it will flag up. It's that very particularistic, institutionalized concept of inference to the best explanation that you mean. It's also related, now I think about it, to what you said ages ago, I think in response to somebody else, could have been me, about the idea of where we start from. I think it was in discussion with Larry as well, starting, because that itself is not, you know, a brute notion where we start from. I mean, when a lawyer says that, you know, one's thinking of the beginning of the case, where, you know, where the distribution of risk or error might be at that point in the litigation. But that's not literally starting at the beginning. Lawyers have already built in, particularly lawyers from common law jurisdictions with adversarial process, have already built in loads of assumptions at that point where we start from. So, you know, one of the things that I see going on in your conversation with Larry is that Larry's thinking at large and making the point at large. Lawyers, we assume that if a case of any importance has gone to trial, it's an arguable case, it's arguable both ways. Therefore, we assume ex ante that there aren't loads of litigants with rubbish cases coming to court because they would have been weeded out ages ago. So the assumption for us at the beginning, unquote, is that these are all perfectly arguable cases for which evidence can be adduced. And I just think that's kind of... So the link between the 2 points is that we're trying to spell out our assumptions in order to make interdisciplinary conversation work. If we don't make that effort, we'll just talk past one another and just replicate our own, you know, biographies, which is kind of interesting to a point, but not that interesting. So if we want to make genuine progress, we have to have language that we can use to communicate to one another. That being the case, that gives us at least one criterion for the virtue of concepts. Concepts should be transparent as far as possible and usable, particularly in an interdisciplinary conversation. Coming back to inference to the best juridical explanation, I suggest to you, and it's just occurred to me, it's just a thought, I suggest to you that's a more transparent concept for these purposes than the one you were using before, albeit it involves 25% more words.
All right.
Oh, 15% more words. Sorry.
Thank you.
Okay, that's all. Thank you so much.
Thank you.